Ladies and gentlemen, good afternoon, good morning, good evening, wherever you are. Thank you for taking the time to join us today. My name is Rajat Mukherjee. I'm a partner at Khaitan and Co. in the corporate M&A team. In the webinar today, the panel of experts that we have put together will discuss litigation finance and whether and how Indian companies and others might be able to use litigation finance. While the concept of litigation finance is not new in India, it dates back to middle of the 1800s with cases cited since then. The reality is that it has not been very widely used or is available domestically for Indian companies. I think that this trend is changing. Globally, the litigation finance industry is booming. A recent report I saw said that it's growing at over 8% CAGR and will hit $22 billion by 2027. So if you look at the reasons for this growth in this industry from the funders' perspective, I think this is an asset class. This is a fairly new asset class which gives financial sponsors the ability to diversify their portfolio. It is independent of and it is not correlated to the traditional stock market. It has delivered very good returns. Globally, average returns are around 35%. And finally, it has allowed time to liquidity in this sector is also fairly short, about 2 years, which means the time it takes to for you to recover your investment along with reasonable return is 2 years, which is fairly good compared to a lot of other asset classes. From the fundies' perspective, it's a great tool for them to outsource their litigation costs. It helps them to reduce the hit on their P&L on an annual basis. It helps it evens the playing field for smaller business houses to fight the state or other larger counterparties. It unlocks working capital and liquidity for companies. And I think it also helps them get access to the best legal talent available. I think in India, with the increased complexity in regulatory and legal complexity especially in the last 10 to 15 years, there's been a sharp spike in the number of domestic and cross-border litigation and arbitration that the Indian businesses are involved in. I can tell you as an M&A lawyer, I work very closely with some of my partners, and in every investment document that we currently do or have been doing for a number of years now, we insist on international arbitration as the dispute resolution mechanism to be done under SIAC or ICC. For both SIAC and ICC, India is at the top of the overall number of parties worldwide filing new arbitrations in any given year. I believe in 2020, Indian users exceed 50% of total foreign users of SIAC. Coupled with this is the fact that expenses of litigation has gone up. If you look at just listed Indian companies, they spent in excess of $6 billion in 2019 for their legal expenses. And there is therefore a great deal of interest from within corporate India and from outside India in the potential market for litigation finance in India, which makes this webinar a very timely webinar for the audience today. Our aim today is to give you an insider's view of the potential market for litigation finance in India and what litigation finance might offer Indian clients from the perspective of the panel experts, the experts that we have on the panel today who are interested in and are all active in the Indian market. We will aim to answer questions around litigation funding, including how it works, who should consider litigation financing in India, What type of claims are commonly funded? How much does it cost? And what should an Indian party keep in mind and consider when seeking or engaging with a litigation funder? Today's format is fairly simple. It's a panel discussion. I will pose some questions to the panelists, and we'll try and keep it conversational, and it will be followed by a Q&A session. Members of the audience, some of them have already sent us some questions in advance of the webinar, which we will try and pick up. There is also, I think, a chat box. So please do, if you have additional questions, please post them on the webinar portal. If we cannot cover all your questions, we will try and answer them over email after the webinar. Also, a copy of the webinar, of the presentation, and a recording of the webinar will be made available by email after the webinar. So let me bring in and introduce our panelists today. I think every person who's registered for the webinar has already received an email with particulars of the credentials, and so I will not spend a lot of time introducing each one of our panelists again. But other than to just say that, look, we are very fortunate today to have three senior executives from some of the leading global litigation financiers on our panel, namely Sindhu Sivakumar. Sindhu is a senior investment manager at Innsworth Advisors Limited, who fund high-value litigation and arbitrations across the world. Sindhu's portfolio is global, and she is a dual qualified and experienced litigator in her previous avatar. Next is Quinton Park. Quinton is director at Burford Capital, which is a leading global finance firm focused on law and the largest provider of strategic capital to the legal market. Quinton is responsible for leading Burford's office in Singapore and for expanding Burford's resources in supporting clients across Asia. And then Tom Glasgow. Tom is the Chief Investment Officer Asia for Omni Bridgeway, a global leader in financing and managing legal risks. Tom is responsible for managing Omni Bridgeway's investment team and portfolio of funded cases throughout Asia, including arbitration, litigation, and insolvency claims. In addition to the three experts on the panel, they are joined by two of my friends and partners, Sanjeev Kapoor and Rajat Jariwal, who are very experienced litigators and arbitrators practicing in India. So let me start by kick it off by asking Quinton to set the stage for this webinar. And given the background, Quinton, and the novelty in some ways of this sector and practice in India, can you start by defining what litigation funding consists of? How do you define it? What are some of the key features of litigation funding?
Sure, thank you, Rajat. First of all, I'd like to say thank you to Khaitan & Co for organizing this very topical webinar and for inviting me to participate. I'm delighted to be part of this very interesting event. So in terms of what litigation finance is, at a very high level, what we do is it's a situation where you have a third party, so a party that is not related to the dispute itself, so not the claimant, not the plaintiff, not the defendant. But this third party would provide financing for usually all the expenses that are related in bringing the claim. So if we fund the claimant, we pay for the legal fees, court fees, arbitral institutional fees, cost of experts, so all the disbursements. It usually works for claimant, but we can also do respondent or defendant funding, which I'm sure is something I will go into later on today. Now, the main characteristic of this type of litigation funding is that we provide capital in return for a share of the recovery. So if the claim is unsuccessful, then the claimant doesn't lose anything. So the risk is solely on the litigation funder. But if the litigation or the arbitration is successful, then we would be entitled to a share of the proceeds or the actual recoveries from the case. So that's very different from other types of financing. So we don't just provide capital and get repaid principal plus interest. The nature of the capital we provide is what we call non-recourse. So we don't have recourse to the client in the case that we lose and don't get anything back.
That's interesting, Quinton. It almost sounds like sounds like a free lunch, which it is not. But I think it's very interesting, because I think to understand historically how people have reacted to and any kind of negativity around the concept of litigation financing, especially in India, I think let me ask Sanjeev, in terms of just the legality of litigation funding and financing in India. What's your view, Sanjeev, from the Indian context?
So Rajat, as you pointed out, I think litigation funding as a concept has been around in India for a few centuries. In fact, if you look at one of the earliest cases, it dates back to 1825, wherein a third person agreed to finance an appeal for half of the share of the estate. But the court therein did not consider such agreement favorably and said that the transaction favored strongly of gambling, and also that the contract to give half of the estate for a small advance was not fair. And there are cases in between also, and the condition almost remains pretty much same till 1852. In 1852, and I think which is the law which is prevalent till now also, while the court was dealing with the contract of third-party funding, the court clearly in that case held that there is no law in India which prohibited as illegal for one party to receive and other to give funds for carrying on a suit merely on the promise of a certain consideration in form of a share of the property sued for. Now, this position was fortified by Privy Council decision in 1876, which is quoted as a law on this particular subject even today, wherein Privy Council held that an agreement to supply funds to carry on a litigation in lieu of having a share in the property if recovered is not per se opposed to the public policy of India. In fact, actually, it went a step further, and it said that the arrangement will actually be in furtherance to right to justice. And these kind of arrangements are necessary to resist oppression as a person who has just rights to a property, but he has no means except for the property itself. And that such person should be assisted in these kind of matters. Therefore, I would say historically, the law has been more advanced in the context of third-party funding, and common law concept like champerty and maintenance was not held to be applicable to Indian law. In fact, this is old case law, but as late as in 2018, Supreme Court of India in a case of A.K. Balaji, while holding that the lawyers as per the professional rules of India can't fund litigation, did find and give an observation that there is no prohibition for third parties to fund litigation. So as a concept, it has been tested. And as you said, it has been around for more than a century and held not to be prohibited by Indian law. However, I must add here that courts in India have also held that they will always have the power to scrutinize the independent third-party arrangements and see if such arrangements are fair and reasonable. And they would have the ability to strike down such agreements in case the court comes to a conclusion that such agreements are unconscionable, oppressive, or extortionate. So that appears to be law. In fact, before parting, I'll just add one more point, and to support as to why I think third-party funding is acceptable. There is a provision in the Code of Civil Procedure of India which recognizes actually such financing arrangements. We have got an Order 25 in Code of Civil Procedure, which deals with civil litigations in the country. And that Order 25 deals with security on cost for plaintiff in a litigation. And some state amendments, not all, but some state amendments to such provision deal with a situation where a plaintiff, for the purpose of being financed in a suit, transfers or agrees to transfer a share or interest in the property. The law then does not say that these agreements would be unenforceable, but on the contrary provides for a mechanism in which a security for cost of litigation can be ordered in favor of the defendant to the suit. So this clearly is an acceptance of concept of TPF in a statutory enactment. So I think based on all this, on the case law and these kind of statutory principles, one can say that not only there is no prohibition under Indian law for a TPF, but to the contrary, there appears to be some kind of a statutory support in favor of it.
And going by the recent judicial kind of trends in the last few years, where the courts have not interfered in what parties have agreed to contractually and enforced that and not kind of allowed public policy challenges, I think it's a good and clear kind of message, right, Sanjeev, in terms of therefore the legality and the questions around that. So I think given that, Rajat, what is what is the level of activity and in India and the kind of current landscape in India as far as litigation funding is concerned?
Oh, thanks, Rajat. It's both an interesting as well as a difficult question to answer. So as Sanjeev said, in India, litigation funding is not a novel concept. And while it has been in existence for a very long time now, some important developments, particularly in the last few years, have brought renewed focus to the litigation funding discourse. Let me attempt to summarize the important ones for you. The first one is the exponential growth of international arbitration involving Indian parties, BIT claims against India, acceptance of arbitration as a preferred dispute resolution mechanism between two Indian parties. Now, this has all, according to me, led to a renewed interest and focus on litigation funding in India. Indian parties are becoming increasingly aware of the benefits of litigation financing, while at the same time, international funders are also keenly looking to tap into the international and domestic market to start with. The second important aspect, Rajat, according to me, is the recommendation that Justice Sri Krishna-led high-level committee on institutionalization of arbitration in India gave. Now, what the committee said is that there is need to enact legislation to augment and support arbitration in India. Interestingly, in its report, the committee specifically noted the statutory recognition litigation finance has been accorded to in Singapore and Hong Kong. So if one were to look at the report, and since it was tabled before the legislature, the legislature in India is not oblivious of the dynamics and are mindful and in fact conscious of the impetus litigation finance would provide on the development of India as an arbitration hub, if I may put it like that, Rajat. Now, this coupled with the current COVID-19 pandemic, which has caused unprecedented sort of economic stress to corporations, thereby creating pressure on their cash flow. So for instance, take the case of construction companies. They have thousands of crores stuck in arbitration claims, regardless of the COVID-induced, financial crunch. As a result, they are neither able to complete their ongoing projects, nor are they able to bid for more, and they have to, in fact, take recourse to additional debts. Now, litigation financing, in that sense, would be a game changer, Rajat. And if one were to talk about certain examples in the Indian context, we have all seen from whatever little is available in the public domain, the case of ERA Infra Engineering Limited, against which IBC proceedings were initiated, and which had actively considered assigning claims against its customers to an SPV in order to use the proceeds from the sale of the claims to repay its lenders. So that was one innovative mechanism that was thought out. There are of course little information about other cases such as that of Gayatri Projects, Hindustan Construction Company's assignment of claims to a fund, Patel Engineering's assignment of beneficial interest in certain actionable claims. These are all endeavors which the companies had made towards monetization of their claims, so as to improve their financial health, if I may put it like that. So
let me ask, Tom and Quintin, maybe Tom, you go first. Given the kind of the context that Sanjeev and Rajat have set in terms of the legality and the interest definitely that exists in India, can you talk a little bit about your experience and generally what international third-party funders are how active are they in India and what are you doing?
Sure. Well, thanks, Rajat, and it's an honor to be here today with you, and thank you to Khaitan and Co for hosting us. I think the fact that we're here today to discuss this topic should give you a pretty clear indication of the interest we have in the Indian market. And I agree with everything that Sanjeev and Rajat have said so far. At Omni Bridgeway, we're already actively supporting Indian businesses in their offshore disputes. And we've been doing that for some time. That includes international arbitration and offshore litigation. And really the high levels of both inbound and outbound investment in India mean that trend is likely to only continue. Those types of cross-border deals often give rise to very high value and complex disputes that are suitable for funding, and we're interested in them. In that sector, in those international cases, we've seen interest from a wide range of sectors in India. Includes the energy sector, resources, construction, TMT, insurance, pharma, and so on. For us at Omni, another key focus is helping Indian parties to collect on awards and judgments and debts against foreign parties and foreign assets. And to do that, we really leverage the expertise we have in-house with asset tracing, intelligence, and enforcement teams. Those opportunities are arising not only from the Indian corporate sector, but also from financial institutions and resolution professionals that are managing insolvent estates. Looking more at the local market, as Rajat was talking about earlier, I'd say our interest is also high, but at least for us, we're really at the exploratory stage there. I think while the local disputes landscape has had its complications and delays in the past, there have been meaningful improvements in the legal framework, at least for domestic arbitration, enforcement, and insolvencies, that have given us increasing confidence in the Indian market from a funding perspective. Others may have different views, but that's at least how we're looking at it. Of particular interest is the domestic arbitration and award enforcement space, and as Rajat mentioned, the construction and infrastructure sector in particular. I think there's real scope for our industry to provide meaningful relief to that sector at the moment and help them realise some of the value that's tied up in those contingent claims and awards. I would say that I feel like we still have a lot to learn about the Indian market, and those of us wanting to develop it will need to be adaptive and creative to meet the local needs and local risks. That's certainly something we've learned at Omni in the past 30 odd years of going into new markets. Local knowledge, local understanding is absolutely critical to risk management and success.
Quintin, your thoughts on this?
Sure. We're just picking up on one point that Tom mentioned, which is award enforcement. So when I said earlier that litigation funding is the financing of a claimant's expenses prior to getting the award, the way we look at the industry, it's actually broader than that. So litigation funding is one form of what we call legal finance. But equally, after you have obtain the award, there are things that you can do with the award. You can come to us and get funding for the enforcement proceedings, there are ways to also monetize the award. So if you don't want the risk of enforcement, we can consider actually buying the award of the claimant, of the award creditor, and then they get money up front, and then they have the luxury of walking away. So these are all different manifestations of legal finance. So it's not necessarily just litigation funding. From that perspective, India has been particularly interesting in terms of the activities that we've seen. If I may describe, I guess, two aspects of the Indian market. So first of all, the legal practitioners. The level of interest in litigation funding has really increased in the past couple of years, and also the understanding of how it works, and more importantly for us, how to describe it, how to really introduce the concept to clients. So that I think is very encouraging. So we are having a lot of these conversations every day with Indian legal practitioners. In part, these would relate to overseas arbitrations and litigation, but there's also increasing interest, like Tom said, in how to apply litigation funding or legal finance in domestically seated arbitrations. So that's the legal community. In terms of corporates, what we have seen is they haven't yet really had the exposure to the power of this tool. So they now are beginning to hear about it from the lawyers, companies that are involved in offshore proceedings. Invariably, they would be aware of litigation funding and how it works. So those companies which are the bigger corporates, multinationals, so they would be more familiar, and there is increasing interest from that sector. But I think the two most important catalysts that we've seen in the past, I guess, 18 months are first the IBC. So that's really making people think about what we do in a slightly different way. So not necessarily looking at us as a provider of capital or a diversifier of legal risk. So they don't want to bear the entire exposure of not winning the case. So they want to offload some of that risk to a third-party funder. That's still a motivation. But since the IBC, we've seen companies who reach out to us requesting for funding, and that's because the motivation there is all driven by company balance sheet. So it's an optimization of the finances. So because of the framework under the IBC, there is pressure that is brought to bear on CFOs and so on, trying to just really improve the company's finances. One type of assets that they see are capable of being monetized are legal claims. So we're seeing the narrative really having developed differently from other jurisdictions because of the impact of the IBC.
I think from go ahead, finish your thought.
So I was just going to mention that the second catalyst is definitely COVID. So how that has changed the landscape is no longer are we having parties who they struggle to find the capital to bring claims. After COVID, we are seeing a lot more well-capitalized companies, so bigger companies coming out to us, may not necessarily be in a position to actually have cases funded or having the understanding, the comfort to get cases funded, but definitely much more willing to explore how legal finance works. So the type of users of legal finance we see also has changed since the onset of COVID.
So that actually segues really well into the question I had for Sindhu in terms of, who in India, Sindhu, do you think should be considering litigation finance seriously, and why? I mean, we've heard from Quinton, Tom, in terms of some of the drivers. I mentioned that in my initial discussion as well. But can you shed some light on that?
Sure. Thank you, Rajat. In some ways, I think Quinton and Tom have answered that question, and I think the answer is pretty much every potential claimant should be considering litigation finance. It's litigation finance, obviously, almost essential in distress situations, right, where a claimant simply does not have funds to bring a claim. So insolvency estates are a great example, where especially where they need litigation financing to bring claims to recoup the estate's assets. And we see that again particularly in India, because the existing creditors, which are usually the banks, are typically not willing to lend, or in a position really to lend further to pursue these good claims. So then litigation finance becomes essential. And then similarly, we also see requests like this from Indian companies for funding for BIT arbitrations with respect to their foreign investments, because they've had their assets expropriated, and again, they have to have litigation finance to bring their claims. But even in, I suppose, non-distress situations, litigation finance can be very helpful in both managing risk and cash flow, which all Indian companies will find valuable. I mean, in terms of risk, firstly, Quinton mentioned this, but litigation finance is non-recourse, right? Which means all the financial risk associated with the litigation is transferred from the claimant to the funder. Now, that by itself is a reason for every company to consider using it, because I think, as we all know, litigation is pretty risky and unpredictable inherently. Like, however good your claim is, things can go wrong. And when you self-fund the case, you bear all of the risk of it all going wrong. And losses can be substantial for Indian companies, particularly with their international disputes, where legal fees are quite high. And then I think, apart from risk mitigation, what we've seen practically is cash flow management really is another major reason for even well-funded companies to consider litigation finance. Because when a company self-funds a case, right, they've got to use their cash to fund the running costs of the litigation. I think someone mentioned it, sort of the monthly payments that need to be made to the lawyers, the expert fees, the court fees, and so on. Now, depending on the number of disputes a company has and the size of these disputes and the jurisdiction where these disputes are, that the hit to its cash reserves can be quite substantial, because litigation takes a number of years really. And this is cash that can be otherwise used for productive purposes, right, for its core business activities. Whereas when a funder is involved, the funder pays these running costs of the litigation. So the cash is free to be used for core business activities, really. Again, so to bring it back to India, I think we find this issue is particularly relevant for Indian companies, foreign operations, and their subsidiaries and their disputes. And I think this comes to the fact that cash flow between India and these foreign subsidiaries is quite heavily regulated. So preserving cash is a particularly important consideration for these foreign subsidiaries. And we found it to be a big driver in them opting in for litigation finance in the past. I think then there are sort of softer advantages really to having a funder involved. It can be regarded as a show of strength sometimes and provoke an early settlement. Most funders are usually, have substantial international litigation experience, which some claimants, particularly the more inexperienced one, find valuable. So I suppose the answer to the question is pretty much every potential claimant would do well to at least consider litigation finance, whether it's a matter of need or not.
So again, just taking up on that segues into my question to Quinton. What type of claims will you guys fund? What are some of the things that funders are excited about? I'm sure it's not me suing my neighbor. There has to be some thresholds that you apply. How do you choose the claims that you will fund? And in India, what is something that you will be excited about and not so excited about when it comes to Indian and claims that Indian corporates may have?
Sure. If you tell us who your neighbor is, we actually might get excited. So you never know. I guess the importance of, or the most important criterion that we look at is really the damages, because of just the concept of what we do. We ultimately focus on the recovery, and how big a share of the recovery we can get. So that really removes the whole claims from being able to be funded. So if you're looking for purely for injunctive relief, for an injunction, then you go to a funder. We're not going to be really that excited. So we may still give you support, but it's going to be more support rather than financial support, I guess. So that doesn't quite work. Now, in terms of damages, people ask us this question: do we only get interested in big cases? And their answer is there's no black and white rule saying we don't fund cases under a certain size. What really matters is the amount of investment that you look to us for. So the case budget relative to the claim size. And the idea is, because as we all know, when you bring a claim, what you claim for, you often don't get the full amount. Right? In fact, you usually don't get the full amount. And then you consider the possibility of settlement. So what you actually ultimately recover could be a fraction of what the claim size is. So once you consider that, and you consider the amount that a funder would be taking out of that share, so it could be a multiple of the invested amount or a percentage of the recovery. So we can talk about pricing structures a bit later on. If you don't have a sufficient buffer between the claim size and the budget, once we have our take, you don't really leave very much for the claimant. So if the claim is not big enough relative to the budget, it could turn out to be a bit of a Pyrrhic victory for the claimant, because he or she wouldn't get anything back, or not much back. So that's really maybe the most important consideration for us. Again, it's not something that lawyers or the parties themselves have thought much about before coming to us, but that's most important. But in terms of the nature of claims that we are able to fund, really there's no limitation on what we can fund. So typically these would be contractual disputes, JV disputes, and we've seen quite a lot of recently, construction disputes. What tends to be easier for us is if the dispute is more legalistic in nature. So the issue that is being disputed is a legal point, because what we do is effectively putting a price tag on legal risk. So that's the type of risk that we want to take. If there's a heavy factual element or requiring a lot of expert input, that often becomes harder for us, because to get expert input, you usually would need some capital in order to commission a report from the expert, for example. So those heavily factual or very technical disputes tend to be a little bit more challenging for us. But other than that, it's really the whole spectrum of claims, from simple contractual disputes all the way to big investor state claims, representative actions, so class actions. That's really the genesis of litigation funding. Competition claims or antitrust issues we have seen quite a lot of. So really, it's really a whole spectrum of claims that we can participate. Now, you asked about India. I'll just say a very quick word about India. India, again, when it comes to claimants in overseas proceedings, that's no different when the Indian party is involved. But when it comes to, and that's something that Tom alluded to earlier, when we look at proceedings within India, then a whole host of considerations, again, of course, would come into play. So regulations, FEMA implications, repatriation issues, so all those things are things that we would have to work through.
Yeah. And just in terms of Tom, next one's for you. For an Indian, corporate house considering accessing litigation funding, what process should they anticipate when they're seeking funding?
Sure. Well, I don't think the process would necessarily be different for an Indian business as opposed to other businesses that we work with around the world. There will be some variation in the criteria and processes between different funders, but by and large, at least in my experience, most funders, at least the international funders, tend to follow a similar format. In terms of the approval process, really the first step is to get an NDA or a confidentiality agreement in place fairly early on. That's there to protect privilege and confidentiality in the discussions. We want to encourage very open and forthright discussions about the case, its strengths and its weaknesses. And we'll want to look at privileged legal advice that the party might have received. So it's critical to get that protection in early on. Usually then there'll be an initial due diligence period where we'll want to understand the basis of the claim, any likely defences, its likely value, who the respondent is, and a rough estimate of the costs of pursuing the case through to a conclusion. And typically that's achieved through a short briefing memo or a discussion with the client and the legal team. Based on that initial due diligence and understanding of the case, we'll try and issue indicative terms fairly quickly and align with the client on commercial terms in a term sheet. And we try to do that as early as possible so that nobody's investing time and money in what can be quite a complex due diligence process if we're not aligned on the commercials. So once that's agreed, we might do a deeper dive into the due diligence, and that really depends in terms of time and complexity on the nature of the case and what needs to be done. We sometimes invest what we call seed capital at that point to help shore up the viability of the case. Often that's focused on quantification of damages, as Quentin alluded to, very important point from our perspective. Sometimes also around recovery and the prospects of enforcing against the respondent. Often we're developing multi-jurisdictional and multi-asset enforcement strategies that involves needing to do some intelligence work around that. Assuming all the due diligence stacks up, then we go to our investment committee for approval of the investment. That committee, in our case, consists of retired judges, sitting arbitrators, and senior people within our business. If they agree that the investment is a sound investment, then we'll enter into a funding agreement and we collaborate on the case going forward. So that's more or less the process to expect. I would like to give one tip to those listening, perhaps, on how to make the process smoother. One thing I would suggest is really not to oversell your case. Don't exaggerate the quantum. Be open about the weaknesses and the strengths of the case, and realistic about what it's worth. Nothing puts us off quicker than obvious issues being hidden from us, or the strength of a case being exaggerated. So it needs to be an open and frank dialogue, and that's your best way to see it through.
And start to finish, Tom, I mean, what's the time frame that we're looking at for this process?
It really ranges, Rajat, depending on the complexity. I think the quickest I've been involved in was 2 to 3 weeks. I've also been involved in other matters that have taken almost a year to get from inception to a funding agreement, and they're more complex portfolio type arrangements where there's a lot to look at and work around. It really depends on the case. If there's a need for urgency, we can obviously move more quickly, but it really depends on the complexity.
So Sanjeev, from an Indian perspective, you know, based on what we heard from Quentin and Tom just now, what would you say are some of the safeguards that an Indian party should consider, you know, in terms of litigation funding? What should they be aware of going in?
So I would say international best practices are something which would be good for India also. And if we are guided by the case law, I think, as I have earlier said, there is no kind of absolute prohibition under Indian law which essentially says that such contracts are contrary to public policy and therefore illegal, etc. So therefore, there is obviously a legality which is attached to it. But having said that, I think courts have ruled that they will always have the power to examine the terms of a third party arrangement itself, and to see that the terms thereof are fair, reasonable, they are not extortionate and unconscionable. So I think if one thing which I have to say from Indian perspective, looking at how the courts have interfered, etc., would be, I would say that the guidance would be that such agreement should be equitable and even-handed, and should be respecting the rights of both sides. I think if care is taken that you are able to justify that consideration is not excessive, it is a consideration which is a consideration as per acceptable industry standard, as is emerging in this particular space. I would say if in addition to other obviously safeguards which are there known globally, in case the agreement is slightly kind of tweaked to take this consideration into account also, um, uh, in my view, a court is not going to then interfere in any kind of a private arrangement which will be between the parties and would uphold a third party arrangement. That would be my view.
Okay. So just moving to costs, Quinton, I want you to touch upon this. I think it's an important element to any litigation strategy planning anywhere in the world, but especially in India. What is the cost of litigation funding? How do you kind of balance the risk reward from a client's or a fundee's perspective?
Sure. So Raja, you mentioned risk reward. I think that's probably the most important consideration for us. Maybe just by way of explaining how we fund ourselves. So we are a specialized financier. So we're not a bank. We're not your typical financial institution. So our own cost of capital is actually quite high. So Burford, for example, we have a public credit rating. So we are rated BA3 by Moody's and BB- by Standard & Poor's. So you can see from our rating and the public debt that we have, we are a high yield issuer. So parties don't typically come to us because we are a cheap source of funds. Now, the way to look at our pricing is really to look at the risk reward, because we look at cases as investments, and they are very risky investments because the outcome is binary. So either you win a case, in which case you could get attractive returns, but the flip side is you lose everything that you've put in. So we reflect that in our pricing. So the way we price our funding is really based on the risk that we perceive are involved in the case, and also a certain return hurdle that we aim to achieve. So it's no different from, you can think of us as a specialized form of private equity. So instead of backing investments, we back cases. Instead of backing management teams, we back legal teams. But the way we look at pricing, the way we look at returns, are actually very similar.
Yeah, that makes a lot of sense. Tom, just looking at structures, I mean, can you tell us a little bit about the different structures and the different types of funding structures that major litigation funders offer, and what kind of deal terms do you typically have in your term sheet? Is there a long stop, for example? I mean, it's non-recourse, of course, but what does that mean? What's the fine print say?
Right, it's a very difficult one to answer because there is a huge range in approaches, and really depending on the particular case, the jurisdiction.
Well, make your best offer for corporate India who's listening in, right? So.
Well, absolutely. I mean, from a structuring perspective, there's huge variation, really. You know, a typical structure is to assign a share in the proceeds to the funder in exchange for the funding that they've provided. Others use will pledge a share in the proceeds, or there might just be a simple contractual obligation to pay, depending on the outcome. In some cases, there'll be a security interest over the funder's entitlements. But really, regardless of what structure is used, the intention will normally be to create a limited or non-recourse interest in the outcome of the case only. The intention is really that the funding arrangement will be balance sheet neutral for the funded claimant. We don't want to create a liability on the balance sheet like a typical loan structure might. So those are some of the structures that are used for very simple single cases where you're funding a claimant. It becomes more complicated when we're funding portfolios, defences, or cases where there is no monetary relief. There's a broader form of commercial benefit that we might be funding the party to achieve. And in those circumstances, you might see a blend of possibly equity interests being taken by the funder, an element of recourse debt coming into it as sort of part of the overall deal. There's really no limit to the creativity that can be involved in those kinds of arrangements, which might be music to a corporate lawyer like your ears, Rajat. As to deal terms, again, these will vary on a case-by-case basis. I think essentially we view litigation and arbitration as an investment class, and like any other investment class, the higher the risk involved, the higher the return that the investor expects. Similarly, in relation to length of time, the longer we are invested, the higher the return that we would expect. So if the case takes 4 or 5 years to complete, then we'll expect a higher return than if it settles within the first 6 months. There really is no one size fits all. It really is an individual risk assessment in the case. There are ways of reducing the risk that we take on and thereby reducing the cost of funding in the terms that we offer. You know, a simple way is to share the costs with us, and often our corporate clients are now choosing to do this. They're saying, well, you guys come and take 50% of the costs here, we'll take the other 50%, and thereby, you know, our risk is reduced as a funder, and our return expectations are reduced as well. In some jurisdictions, the lawyers can take some risk as well, and we encourage that where we can. And then the other way that we can potentially de-risk is by using a portfolio to diversify our risk across a number of different cases. And in those circumstances, sometimes if there's true diversification, our risk is reduced and we can offer more attractive terms. So I know that's a long answer, but it is a nuanced approach that we take to deal terms, and every case really is different.
Okay, that's very helpful. But I think in that conversation, you know, you talked about risk reward. So I want Sindhu to come in, and Sindhu, talk a little bit about risks that a fundee or an Indian corporate looking to take on litigation funding. What are some of the risks that, you know, they are taking on board when they agree to go down this path? What should such a party look for in a funder?
The major risk really is of the funder not being sufficiently well capitalized to meet its obligations under the funding agreement. That's sort of the primary risk that you'd want to diligence and avoid as a claimant. So yes, I think so. Check the funder's financial standing. Another sort of maybe related check you might want to do is understanding the funder's approach to things like, you know, settlement and duration of the case. As a claimant, you know, you don't really want to be pressured into settling too early or too low. And this is partly a financial check, because you want to make sure your funder can put up capital for the full duration of the case if needed, just to make sure you wait for an optimal settlement. But it's also, I think, a matter of approach. Some funders work with specific timelines in mind, whereas others don't. So that's also something you would want to check.
But just to pause you there, I mean, in terms of checking the kind of ability of funders to fund, I mean, is that done usually you expect to see some kind of a diligence, or is that just basis just reps that they provide in terms of their ability to fund? What is the market practice here when you say, how do you diligence that? I mean, of course, I
would ask a funder to tell us exactly how well capitalized is it, the source of its capital, whether there are any pressures in terms of, you know, when it needs to sort of recoup its investment and its returns and so on. I think it's something most funders would be happy to be transparent about. And bear in mind, this is something that may come up in any case during the proceedings, right? If you, one of the things that often happens in international arbitrations and litigations is that usually you will need to disclose that there is a funder involved to the other side, and then once the other side knows that there is a funder involved, then inevitably there will be questions or even an application for security for cost to make sure that in case the defendant wins, the claimant or its funder are able to pay the adverse costs. So instead of that becoming an issue much further down the line, it's, I think, well worth checking to make sure that the funder can meet its obligations upfront. Then some of the softer things, really, I think you may want to check. You know, what will the relationship be like? Will you be able to work with the funder over the duration of the case? Will they add value to you in terms of, you know, case management or in terms of case strategy? And also, is that something you want? Like, some very sophisticated litigant might prefer a funder who's very hands-off. A more inexperienced claimant might value more inputs from a funder. So I think these are sort of some of the things you want to check about a funder when deciding who you're dealing with.
And do you in terms of the inputs from a litigation perspective that you were alluding to, for example, how does that work from your perspective, Sindhu? Like, do you have you know, lawyers on hand? I mean, you yourself are a lawyer. Is that something within your remit, or is it something that you know, look outwards for?
So in terms, I mean, I think firstly, in how involved we tend to be in the litigation is it varies jurisdiction to jurisdiction. So some jurisdictions, you're expected to be quite hands-off, and also the rules around things like privilege, etc., means you just cannot get quite as involved as you might be able to in other jurisdictions. But where I think we're able to, and where we're asked to, at least at Innswood, we're more than happy to, you know, get involved and provide strategic inputs as needed. And in our experience, claimants like that. They find that quite valuable to have another pair of eyes looking at what the lawyers are doing, and the lawyers like it as well. It's just you know, you have an extra set of strategic inputs on a case.
Sure. So I think just heading, I mean, more locally to India, and I'll ask this to Tom and Sanjeev both. A bit of a touchy topic, maybe. Should India regulate litigation funding? You know, how should they do it if they were to consider doing it? What have you seen, Tom, in other jurisdictions where they have regulated litigation funding?
Thanks, Rajat. Well, it is useful to look at the rest of the world and some of the more developed markets for our industry. The UK and some of the other developed markets have generally adopted to promote a self-regulatory regime for the industry. Other jurisdictions like Hong Kong and Singapore, who have passed some form of formal regulation, have opted for a light touch approach. And really there they focused on high level but important protections like ensuring capital adequacy, something Sindhu touched on, the issue of whether a funder's interest should be disclosed in the context of an arbitration, and so on. I think one of the takeaways hopefully you would have had from today is that there is a huge range in types of litigation finance, and it really has become quite a sophisticated corporate finance and risk management tool. So it's not really an industry that lends itself to inflexible and overly prescribed regulation. And of course, I'm focusing on the corporate use of our funding. In some jurisdictions where there is funding of consumer class actions, then potentially there are more consumer protection concerns that may arise and tie in with the funder's involvement. But really, that's a discrete issue and unique to those sorts of cases. I think as far as the funding industry generally goes, it's really important that we maintain that level of flexibility and autonomy for well-advised commercial parties to structure their arrangements as they want to. With all of that said, I should really mention our recently launched Indian Association of Litigation Funders. A number of industry players, including Sindhu and myself and other members of the Indian legal fraternity, have formed a working group seeking to establish a body to educate the market and bring industry best practice to India. Through that platform in time, we hope to develop some guidelines, take on members, and introduce a self-regulatory regime, really in an effort to ensure the success of the industry in India.
Sanjeev, your thoughts?
So, Rajat, my personal view would be some kind of regulation, a very light touch kind of regulation is certainly going to help. We are seeing a rise in funded cases. We are seeing many new issues which are cropping up. And having some kind of regulation in some form or other will some kind of a clarity to the process. As has been pointed out, there are self-regulations which are being formed by the funders. And there are laws which are being passed by countries like Singapore and Hong Kong. And also, we see that even institutions like HKIC, ICC, and others are including rules which govern certain aspects of funded claims. So, adoption and mix of these kinds of regulation in India, in my view, would certainly be helpful and lend clarity to the purpose. Definitely, there is case law on the subject, but this case law is not dealing with the kind of funding which is happening now. It's kind of dealing with some individual funding, some sporadic case, rather than a very methodical approach of the funders which is prevalent today. So that case law might not be of help. Regulation always helps. The advantage with the regulation is that it will set the rule right at the start itself. And then obviously parties know what is to be complied with, how the participations in the litigations are going to proceed in the litigation, rather than things proceeding on, let's say, an ad hoc basis, and then later on losing party will do a flaw finding exercise into the entire process and procedure and then challenge it. And let me substantiate it by just one example. Let's say law in India is not clear on disclosure of litigation funding arrangement. Under Indian arbitration law, one could argue that there is no requirement to disclose a third-party arbitration agreement to other side. Now, a lack of regulation in this aspect may lead to a situation wherein later on the entire arbitration process may be challenged. Let's say somebody will take a ground of some pre-existing relationship of some funder with, let's say, member of the tribunal and say that therefore the entire award should go. So this will result in entire enforcement that will put in question. Also, there would not be regulations as to if a disclosure is indeed made by the party, then to what extent such third-party disclosure is required to be made before the tribunal. Is the whole agreement required to be disclosed, or bare minimal details will suffice? I think a lot of time can be saved for the parties in case there is some kind of regulation around these issues. It's not necessary that you have a very detailed kind of an enactment which is passed by the legislature. As I stated, there is already guidance which is available on these aspects, whether it's in the form of institutional rules which are governing these aspects. So I think adoption of these kind of rules, whether it is some kind of a self-regulatory mechanism, Indian arbitral institutions becoming more proactive and incorporating that, some kind of a guidance which is coming from the let's say the government, some kind of a light touch regulation which will give a very overall direction to the purpose and give clarity to the process as to how this should be governed, etc. In my view, that would certainly be useful and definitely be helpful to the people who are going to get involved.
So I think two views there: self-regulation according to Tom, and light touch regulation according to Sanjeev. I guess with like many other things in India, we will wait to see what the regulators and the government comes up with if they do look at this and seek to regulate this. But I think just to conclude the kind of panel discussion, and I'll take a few questions from the audience. After that, I think, Sanjeev, can you in a minute kind of just give me, I think based on what we've heard from the panelists today, what is your take in terms of the outlook for litigation funding? I think at least from my perspective, I can just quickly say that it sounds very exciting. And it sounds like we are at the cusp of a real new asset class in India, which should really be a win-win for corporate India as well.
So Rajat, according to me, outlook is bright. So as I think if you look at historically, the law has been more evolved in Indian context for third-party funders, and concept of champerty and maintenance were held not to be a part of Indian law. So I think when we are looking at Indian law and we are looking at third-party funders, we are not really needing a law, let's say like in Hong Kong or Singapore, because in Hong Kong and Singapore, champerty and maintenance were actionable torts and could be acted against. The position is not so in India, therefore we really don't require a law on those aspects. So it has been quite an evolved law. Yeah, the only problem is that it's something which has not kept pace with times. But I think as we see today, the landscape is quite ripe for funding disputes in India. As has been pointed out, there are very substantial, high-stake and complex disputes which are there in India. And COVID and other reasons, there is financial crunch which is making it difficult for companies to fund these genuine disputes. So as has been pointed out by Tom, there is already a heightened interest for litigation funders for disputes in India. And as has been pointed out, in fact, funders are looking at claims which Indian entities may have against foreign entities. Where awards would be against assets which are situated in countries which the rules of litigation funding are clear. There are funders who are very interested, and that is a view which has been shared on this panel itself. But I think the concern which we have heard from the funders is on another large group of disputes where the disputes are situated in India, and enforcement is ultimately going to happen in India. And I would say that as far as that is concerned, the interest is not really as heightened as in the earlier category. And there are some concerns, and some of them genuine about ambiguity around Indian law as to whether third-party funded awards would be enforced in India or not. The historic law would be made applicable to, let's say, the current doctrine of litigation funding, which is much more evolved and much more sophisticated. So the view is there for more than a century, and there doesn't appear to be an ambiguity, but that view has not really been recently tested in India. So I think, I think Tom also pointed out a concern around the slow pace at which the awards might get enforced in India. I would say if that's a problem, that is not really only unique to third-party awards, but to all commercial awards. But I think what is encouraging is that there is legislative as well as judicial intent to enforce awards very speedily in India, and something which is working. Therefore, my view, it remains positive. I think we need one judgment from a superior court of the country on litigation finance and the validity and acceptability of it. And that one judgment is kind of going to heighten the interest
at this stage. Okay.
Seek arbitrations also.
So sorry, just in the interest of time, I think I'll take a couple of questions that I've got from the audience, and the first one, Tom, I'll ask you, which is your view on portfolio funding. For example, if you look at a portfolio of diverse construction claims, how does that work? How do you kind of look at it in your experience?
Right. So the idea is that we combine together two or more different cases into one funding package, and we fund the lot, and we collateralize our investment against the claim value or the proceeds of matters that will produce revenue within the portfolio. The benefit of that from the funded client's perspective is it means that they can fund a broader range of cases. So you might have a particularly valuable award to be enforced, let's say, and then you've got some ongoing claims in, let's take the infrastructure example, in arbitration. You might be defending some other actions. You can leverage the value in that award to fund the other matters, and it means we're less sensitive to the economics on particular cases, and it gives that flexibility to the client. From our perspective, in some portfolios, there can be a diversification of risk. So if it's a portfolio with multiple claims in it, we're less exposed to the binary outcome in an individual claim. Of course, if you've got one claim and you're leveraging that to fund a defence, there's no diversification in that, so it doesn't have that effect. But in some portfolios, it can have that effect, and where we're diversifying, reducing our risk, then we can provide more attractive funding terms for the funded client. So for all of those reasons, it's something that we are increasingly doing. It does lend itself quite neatly to some of the situations that infrastructure businesses in India are finding themselves in, with multiple claims at different stages in the process.
Okay, that's very helpful. So you don't get to you don't cherry pick. You take it as a whole. You analyze it as a whole, and the risk reward kind of balances itself out in some ways once you look at the portfolio, I assume.
It depends on the circumstances. There are some circumstances where we would cherry pick the better cases. It has to work overall, but it does enable an extra element of flexibility to take on cases that maybe will not be revenue producing, or maybe the risk profile is slightly higher.
Sindhu, next questions to you. For a little forward-looking, crystal ball gazing. Is it possible and realistic to expect industry standard litigation funding documents to be available soon?
Yes, I don't know about how soon, but I think there is work being done internationally to improve the efficiency of the litigation funding market and create model documentation, a bit like what the LMA did for the loan market. Now, I think everybody recognizes that there are some clear advantages to this. It'll improve the speed of the negotiation and execution process, which is in everybody's interest. It can, obviously improve and standardize and improve protections for the various parties involved in a funding transaction, and also reduce disputes from badly constructed funding documents. So I think there are some advantages, and the industry recognizes that. When this work will be complete, how far it will go in terms of standardizing documents, I can't quite tell yet. And it's very early days internationally, and it'll probably take even longer to reach India.
I can tell you from a private equity standpoint, I mean, we still don't have standardized documents in India for private equity or VC, funding. So I think let's get there when we get there on that one, right? Let's get the party started first, and then we'll see when we get there. Sorry, just again, last question from the audience, and then I'll move on. Quinton, to you. Quickly, in terms of trends that you see, any trends in litigation funding, any particular sectors Any specific purposes for which people are approaching you?
Yeah, so in terms of trend, what is encouraging is definitely an uptrend in terms of reception and uptake of using litigation funding. So I hope that will continue to be the case. The market is definitely evolving. I think what is important, something I mentioned at the outset, is we are now seeing the well-capitalized, the bigger companies also looking at litigation funding more from a corporate finance angle. So rather than really just working with impecunious claimants and people who are short of capital. So that is very important. I think the holy grail for all of us funders is really to work with the big corporates using something like a portfolio structure, like Tom mentioned, and looking at the claims that a company may have across the world in various jurisdictions. So I think that is really what we are aiming to achieve. And India, in many ways, I think actually has leapfrogged other jurisdictions in terms of that thinking. It's the pace of development is much quicker than what we had expected.
Well, that's good to hear. I think so. On that positive note, I think can I just ask my partner Rajat to kind of sum it up in terms of just some maybe 3 takeaways that we can take for the audience, Rajat.
Yeah, so it has certainly been a thought-provoking webinar. To me, some of the key takeaways from today's webinar, since you had asked me to restrict myself to 3, I'll try and restrict. The first, of course, is
go all out. Say 5.
Thanks. So litigation financing is not illegal per se, or contrary to public policy in India, provided the agreement is not unfair, extortionate, inequitable, or unconscionable. We have judicial precedent from 1852 to very recently 2018 taking this consistent view. To my mind, therefore, there is no danger, of India going the same way as Ireland, where its Supreme Court had outlawed litigation financing. I know it's a very aggressive thing to say, but that's the sum and substance of how the courts have perceived the litigation funding agreements to be. The advantages of litigation finance are for everyone to see. It allows you to leverage capital to enforce rights, and as non-recourse funding, it does not have any adverse impact on your cash flow or balance sheet. Obviously, there are genuine concerns around conflict of interest and disclosure, privilege, confidentiality, extent of control on the conduct of proceeding by the funder. All of which, however, according to me, can be addressed by having a sound agreement with a recognized and, as Sindhu said, well-capitalized third-party funder. We also heard, Rajat, the funders on the panel say that in the Indian context, international and domestic arbitrations are more attractive initially than domestic litigation before the Indian courts because of the uncertainties and delays, presently that get associated with the process. These problems will need to be overcome in time, for litigation financing to be readily available. And to sum it up, Rajat, given the increasing global activity in litigation finance, we can reasonably expect the Indian landscape to develop favorably, particularly because the courts have already ruled on the legality of the concept, albeit with certain checks and balances, Rajat.
Right. Okay, I think that's a great way to sum it up. I think I'd like to take a minute at this point for us to run a quick poll that we do as part of our CLE exercise and webinar series that we do for the audience, just in terms of the your rating for the webinar. So if people can just take a minute to to rate us. That'll be appreciated. The slide also said that organizers and panelists can't vote, which was unfortunate because I would have given myself very high rating there. But I think on that note, I think again, thanks a lot for all the audience and the participants who've logged in. I hope that was a good use of your hour and 20 minutes, and you learned something new. I think for the Indian corporate houses which have logged in, I hope you'll really consider and start thinking, if you've not already done so, in this as an opportunity for you to work with litigation funders for your litigation and arbitration issues in India or outside. To my panelists, Sindhu, Quinton, Tom, thank you very, very much. We couldn't have done this without you. We appreciate you taking the time. And hopefully this opens up opportunities for you to engage more and more with corporate India, which I'm sure is something that you are all working towards. In terms of quick for the audience, we will, like I said earlier, we will send a recording of this webinar to you by email. And at some point over the next couple of days, you'll get an email from our CLE to get feedback on the webinar itself. So with that, thank you everyone for attending the webinar. Thank you again to my panelists, and have a good day. Mitesh and Tejas, if you can just quickly show us the next slide, and then we can conclude the webinar.